Okay, so our podcast is going to kick off, and today I'm going to talk about the regulatory framework for tax in the EU after the Lisbon Treaty. So instead of referring to European Community, I'm going to be referring nowadays to European Union. And I like to use this particular slide to maybe summarize everything that I'm going to talk about this morning, and maybe only use one or two more slides and talk about some cases towards the end. I have to do this in 30 minutes, so I'm going a lot quicker than I would usually do. So please forgive me if I go a little bit quickly. I have this talk written in a number of articles as well and in my book, which you're welcome to read at any time. So if you looked at this for the first time, the first thing that you should note is that if you're from Portugal, this is a picture, a snapshot of the Portuguese tax system. And if you're from France, behind you, this is a snapshot of the French tax system. Obviously, the French tax system will have constitutional law and stuff like that, but this applies generally to every member state that we have in the room. So we have the Polish team down in the back row hiding. This applies to the Polish tax system as well. So even though it's the regulatory framework for tax in the EU, it's also a snapshot of the national tax system. Whether you realize that or not, if you went to school in a law school anywhere in Europe, this is the picture that they should be using to teach tax law in the law school. So if you haven't seen this before, ask yourself why that is the case. And usually that's the case because you're not coming across EU law in the teaching of tax law. Even though EU law, as you're learning over the last 2 days, is fundamentally a very big part of national tax law nowadays. At the bottom of the triangle, I have put the national tax laws. So that's the Greek national tax laws on income tax, corporation tax, and so on. But it could also be the Hungarian tax system. In the middle, I put tax treaties, and that's the national tax treaties. That's the Hungarian tax treaties, the Greek tax treaties, the Polish tax treaties. And in the pink box on the right-hand side, you will see that tax treaties are divided into 3 types. You have member state tax treaties, you have member state third country tax treaties, and you have things called prior agreements. Now, if we take Poland as the example, it's quite easy to use and to explain these 3 categories. So we can have Greece and Poland having a tax treaty. That tax treaty is fully bound by EU law because both parties to the tax treaty are EU member states. So both Poland and Greece are EU member states, therefore they must comply with EU law. How do we know they must comply with EU law? Because the court has told us you must comply with EU law in paragraph 33 of Gottardo. And Gottardo is not a tax case, but the court says that whether the agreements are between 2 member states or between a member state and a non-member state, the member states are required, subject to the provisions of 307 EC, to comply with the obligations that community law provides. So all international agreements must comply with EU law subject to this one exception. And this one exception is dealing with Poland's agreements that it entered into before it joined the EU. So Poland would have joined around 2004, 2005. So it may have had tax treaties with third countries before that date. If it had tax treaties before that date, those tax treaties may contain provisions which are incompatible with EU law. If the provisions are incompatible with EU law and the European Commission challenges Poland, Poland has only 2 obligations. It either gets the agreement of the third country, which is a non-member country, to amend the treaty, or Poland must give notice to terminate the treaty. There are only 2 alternatives. That is the only 2 ways you can fix the incompatible with EU law problem. You either amend or you terminate. And those prior agreements, we haven't come across them in the tax treaty area in the court's jurisprudence, but we have seen bilateral investment treaties being challenged. Bilateral investment treaties entered into by Sweden, by Finland, and by Austria. So I don't know if we have any Finnish team in the room. No Finnish team in the room this year, but the Swedish team are here. Well, around 2009, the European Commission challenged Sweden's bilateral investment treaties with a number of African countries, which they entered into before they joined the EU, and they were found to have provisions which were incompatible with free movement of capital. So we have jurisprudence in relation to bilateral investment treaties. The short name for bilateral investment treaties is BITs, B-I-T, small s, bilateral investment treaties. So the court would do the same thing in relation to tax treaties or double tax agreements, double tax conventions. If you have joined recently, we have some people from Romania here. Romania, Bulgaria. Yeah, so I mean, like, these are the type of things that could happen in your world, that at some stage, some taxpayer may see something in the prior agreements before you joined with third countries. A third country is any country other than an EU member state. So yesterday we were talking, my French colleague over there on the right was talking about the vocabulary. Well, the vocabulary of buzzwords that you need in EU tax are here in the yellow box. So the yellow box, the first buzzword that you need to know about is a third country. And a third country is any country that's not an EU member state. And these people are different to member states. Why? They're different to EU member states because they're not bound by EU law. But if you have a tax treaty or a bilateral investment treaty with a third country, the member state has an obligation to make it comply with EU law. Why? Because the court has said so. The Gottardo case makes it very plain that all international agreements must comply with EU law unless they're a prior agreement. If they're a prior agreement, you have an exception, but you only have the exception and the benefits of the exception until somebody challenges the treaty to see whether or not the provision is compatible or not. If the European Commission challenges, then you must fix it. And if you don't fix it, they'll take you to court, and the court will find that you're in breach of your obligations. And this is what happened in Commission v. Sweden from around 2009 involving bilateral investment agreements, bilateral investment treaties. So I put tax treaties into the middle of the diagram because they're international law agreements. So they're like international contracts. But let me just explain one thing to you about tax treaties. How many people in the room are from a country where the tax treaty is automatically law? If the state enters into a tax treaty, is the tax treaty automatically the law of your state? Or, yes, there will be some. These type of states, bye-bye, Jared. These type of states are...
What do you mean by automatic?
Yeah.
Without parliamentary?
Yes. There are some states, I see up the back there. Which state are you from again? Czech Republic. So the Czech Republic will enter into a tax treaty and that's it. No need for a piece of legislation domestically to make it law. These type of states are called Monist, M-O-N-I-S-T states. Monist. No, they're called Monist states. Trust me, they exist.
Yes.
Now, hang on a sec. Let me...
I mean, technically, we consider ourselves a monist state simply because you cannot actually enter the treaty at all without parliamentary ratification. So it's a bit more...
Yeah. Well, maybe that is a monist state as well. But the dualist states in the room are the ones where a piece of law is passed in Parliament, and that is the law. Now, whether or not that law implements the tax treaty perfectly or not, the courts, if the tax treaty is breached, will look at the domestic rules contained in the domestic legislation. Now, those countries are dualist, D-U-A-L-L-I-S-T. They differ from the monist countries. Hello? France is like this, yes. And yes, monist, a monist state, yes, a monist state. A monist and a dualist. So not every state implements tax treaties in the same way, but I always think of them as some kind of higher piece of law above a domestic rule, and that's why I put them in there, because they're like a binding agreement on the international stage.
Just one question about how do you put the free trade agreement? You know, for example, when you have an agreement between the European Union and
Yeah, all this is in the top box.
the international agreement.
Yeah, they're all in the top box, but here we're looking at international agreements made by a member state only. If the member state is the only person involved in the agreement, then EU law is binding because the court has said so. All international agreements must comply with EU law. It's clear from Gottardo. Now, the Gottardo case teaches us one other important thing. You cannot just read tax cases to understand the tax cases and the tax jurisprudence. Here, you get a clear statement from the court involving tax treaties, because a tax treaty is an international agreement. But the court had given us this answer in an earlier case from the year 2002. And very few people have read it. How many of you guys have read it? Any of you read Gottardo? It's an insurance case. It's insurance law, social security law case. So this is your first lesson on the cases. Sometimes the answer to your problem is not in the tax jurisprudence. It's in another case delivered by the court, and somebody has to be familiar with these cases. And the only way you become familiar with these cases is for somebody to read them. So the tax treaties exist. Why? Well, the tax treaties exist because at the EU level, we don't have tax treaty rules. There are very few rules at the EU law level concerning tax treaties and tax treaty problems. The tax treaty problems are still at the member state level because tax is still a competence of the member states if it's a direct tax. So therefore, we have to have tax treaties. And every member state will have their own set of tax treaties, having their own individual provisions in tax treaties. So the first lesson you should learn from all of this is that you can get some very strange results in the cases whenever a tax treaty is involved. You can get some very strange results because we're not dealing with harmonized rules. So this is how tax treaties fit into the big picture. They exist. Each member state has their own set of treaties, usually on a bilateral basis. The Dutch, not the Dutch, the Scandinavians here have a multilateral convention with the Scandinavian countries. And that's very unique. But the rest of us, we all have everything on a bilateral basis. If you go to the UK, for example, they have over 100 treaties. The French have over 100 treaties with different countries around the world, and usually with every other member state. But if I was to ask Poland, does Poland have tax treaties with all the other EU member states, including Croatia? You have no idea. So the question is that, you see, not every member state has all these treaties in place yet. So if they're not in existence yet, you have problems of double taxation from time to time occurring. Then the next thing happens is the taxpayer comes into the local court and says, oh, I'm suffering double taxation. Can EU law solve it? And maybe EU law, this is discrimination under EU law. And the answer is it's usually not discrimination under EU law if the tax treaty does not exist. So if the tax treaty doesn't fix the problem, then the court cannot really help you. The European court cannot really help because juridical double taxation, where it's taxation imposed by more than one country, has to be resolved in a tax treaty in order to be fixed. And very often it's not. So I draw the line under EU law, and it's above international law and national tax laws in this instant, even though EU law is a branch of international law. Even though it's a branch of international law, you would think it should be at the same level as international law. It's not. And it's not because, again, we know it's not because the court has said so in Gottardo. All international agreements entered into by the member states must comply with EU law, except for that one exception for prior agreements. So if you get that so far, and you get the reason why we have tax treaties, and you understand that we have three types of category of tax treaty, then I can move up to the green box. And the green box is where you have to sort of, do some homework yourselves. First of all, you see in the green box the TEU and the TFEU, and you're looking at them and you're wondering, what are those things? Well, of course, they're the acronyms that you will have different acronyms in your own language. So the Treaty of the European Union will be something totally different in Polish. It'll be something totally different in Lithuanian. So you need to obviously, understand that I'm using the English language today. And the TEU and the TFEU are your two primary constitutional documents. And I need you to put up your hands and show me if you've read them. The Treaty of European Union and the Treaty on the Functioning of the European Union. Some parts. Well, it's the type of thing that you need to flick through once to sort of know what's in there. Saying some parts is not really a very good answer as a judge, because the thing is that an issue could come before you requiring you to apply EU law, and some parts is not a good answer in the courtroom. You have to have at least looked at it. You're not expected to memorize it. You're not expected to know everything about it, because we all have to go back to look at it. But from time to time, it's a good idea when you have spare time to at least have read it all once, and to have read the Treaty on the Functioning of the European Union once, and to become familiar with the basic provisions that relate to tax law. The basic provisions of the Treaty on the Functioning of the European Union that relate to tax law are the fundamental freedoms, the free movement of goods, persons. Persons is split into two. Persons is either workers or establishment. So in other words, a person establishing a business or a person going to another member state to work. Then you're into companies. Companies that are established in the EU countries, Polish companies, Greek companies, all have EU law rights. So long as they have a registered office in the EU and they carry on business here, they have to be respected in the other member states. And freedom of establishment allows a company to set up a subsidiary company, which is a new company. It can set up an agency or it can set up a branch. And each of those forms of establishment are acceptable in the freedom of establishment. Now, the freedom of establishment, free movement of workers, the freedom to provide services, and the free movement of capital, and European citizenship are provisions of the treaty that you would have to become very familiar with as judges. You literally have to become very familiar with the provisions. So if you could do that, that would be a very good start. The next area that you just listened to was Ashling's talk on state aid. Well, they're a separate set of rules contained in the treaty that you need to know exist, and you need to know some of the basic cases. There are a couple of textbooks that can help you on state aid cases, but basically it's a specialist area of activity involving EU tax. Then there's a third area of cases that you come across from time to time. I call them the alcohol cases, the car cases, and the banana cases. And they're basically where member states would use their tax system to block foreign products coming into the country. So to give you an example, 30 years ago in the UK, if you went into Tesco's or the supermarket, you would walk down the shelves of the alcohol products, and the only thing you would see is beer. Why? Because they wanted to block French wine, Italian wine, German wine coming into the country to compete with their own products. Well, there's a provision of the treaty known as the internal taxation provisions, which block member states from using their tax systems to create barriers to products from other member states. I'll give you an example of what the French were doing. well, the French have got this very nice set of cars, Citroën, Renault, and Peugeot. I probably pronounced them incorrectly. But the French tax system would go up at a very nice, slow, as the Citroën was C1, C2, C3, C4, C5, up to the top level Citroën, and the tax went up to here. The next tax was on the Mercedes, the Jaguar, the BMW, the Rolls-Royce. That was somewhere up near the ceiling. So the French tax system was trying to force French people to make a choice, either pay this huge amount of tax or buy the top level Citroën, or buy the top level Renault, or buy the top level Peugeot, which was not too bad in terms of taxing. And they used the taxes to do this. And they were told you can't do this anymore because you've joined the EU when the tax system got challenged. So now you'll see, if you went to Paris in the 1970s, you saw nothing but French cars on the road. And you would think French people are extremely patriotic. And it had nothing at all to do with patriotism. It had everything to do with the tax system. Similarly, in the UK, you could walk down the aisle of a supermarket and not see a bottle of French wine. And this was the same thing going on. The British were blocking French wine coming in by having high taxes on French wine because they wanted to sell British beers, the local produce. And there's a whole heap of cases involving bananas. There's, well, the British, the Italians, all have apple and pears as their main local produce. Bananas compete in the supermarket for the housewife's shopping list. So you compete on a price basis for the fruit bowl in the mother's house, in the shopper's house. And in the old days, everybody outpriced the foreign bananas that were coming into the EU so that pears and apples were always cheaper. It's quite interesting what tax systems do.
And where was the largest producer of bananas?
Probably Italy was probably the biggest in Europe, I think. I see.
I think we find 5 were.
Oh, 5 were, okay. So they're the 3 areas of cases that you'll see the court's jurisprudence. The next area of cases that you'll come across are cases involving directives. Now, I suppose you all know the difference between a directive and a regulation, and I don't need to put that on the podcast. But for the benefit of those who are watching, who don't know the answer, and for the students in the future, a regulation is a piece of EU law, secondary legislation, which is automatically binding on the member states without the member state having to bring in a piece of law. The most common regulation in the tax area is the Common Customs Code, and that governs all foreign products coming into the EU. So, for example, if a Russian bottle of water is coming into Greece, they will pay a tax at the border on the Russian product. And that product will have a product code. And whether the product comes into Greece directly from Russia, or it comes in via Spain or Portugal or Lithuania, it doesn't matter. Each member state will impose the same tax. So if we are doing something with these things, these will have a different product number to the water. And once as the goods pay the tax to get into our market, into the single market, then they are known as goods in free circulation. So once as they're in, they move around like EU goods. And the Common Customs Code has a different category number for every type of product. So in terms of that type of a regulation, it's a very uniform piece of legislation. So it doesn't matter where the foreign goods arrive, whether they arrive in Greece, whether they arrive in Spain, whether they arrive in Lithuania, the same tax is collected at the border. Now, a directive is different. A directive is binding on the member states as to the result to be achieved, but how the member state achieves that result is up to the member state. So the classic example of the directive that you come across on a daily basis is probably the value-added tax directive. So value-added tax is a European tax implemented in the 28 or 29 member states, and each member state will have its own VAT piece of legislation. So you're looking at your own piece of legislation, and that legislation must comply with the directive. And if it doesn't comply with the directive, then taxpayer or the European Commission can challenge the member state to make sure that they properly implement the directive. Now, we have a whole host of VAT challenges. This is a regular problem for courts in all the member states involving value-added tax. The third type of legislation that you can come across at the EU level is EU decisions. So EU decisions, these are binding on the people to whom they're addressed. Then you have the thing that we were talking quite a bit about yesterday was the Charter of Fundamental Rights. Again, I should ask, have you read the Charter of Fundamental Rights? And if you haven't, you do need to read it. You don't need to read it in terms of memorizing it, but you do need to read it to see what's in it. Do you remember we had the big debate yesterday on the nebis in idem principle? Well, the right to a fair hearing, the right to property, etc., are all provisions in the Charter of Fundamental Rights. You also need to have a quick look at an international agreement known as the EEA agreement. It's a strange agreement because we're dealing with three countries basically. Norway, Iceland, and Liechtenstein. And these three countries have agreed to give the freedoms to every member state, and we have agreed to give the freedoms to Norway, Iceland, and Liechtenstein persons and companies. So the freedoms have been extended to these countries, and they have extended the freedoms to us on the basis of an international agreement entered into by the EU and the member states. Now that's significant because these are not member states, but they are members of the EEA agreement. And the EEA agreement have agreed to comply with EU law. And they have their own court, known as the EFTA court, the EFTA court. And the EFTA court does get EU law issues from time to time and has its own website of judgments. And the classic one from our perspective is known as Focus Bank case, in which outbound dividends from Norway to the UK were taxed with withholding taxes. And this case came before the EFTA court, before the same issue came before the European court. And the consequence was that the EFTA court found that these dividends were taxed in breach of EU law. And I have a Greek student working in London working on these repayment claims, and they're worth something like £7 billion, I think, involved in the project at least. So the last topic on the green box, I should mention one last thing. The EEA agreement covers Norway, Iceland, and Liechtenstein, but there's also Switzerland. Switzerland is not a member of the EEA, and it's not a member of the EU, but it has a set of arrangements with the EU, known as, I think, 10 bilateral treaties. And they have a lot of issues. So whenever you come up with a Swiss issue, you need to look at those 10 agreements on the Commission's website. Anything to do with Switzerland, make sure you check to see, is there an EU law issue there? Because sometimes there can be. Then the last thing is soft law. And we heard yesterday things like communications from the Commission, recommendations from the Commission, guidance from the Commission. These are not binding, but they have the power of peer pressure. For example, we have the Code of Conduct on Business Practices since around 1997 or 1998. That's going to become more important as we go into the world of BEPS and implementation of BEPS in the future. That will become more active. And you see over on the other side of the diagram the ECHR. That's the European Court of Human Rights and the European Convention on Human Rights. Well, that has been trickling into EU law via the Charter of Fundamental Rights. So we are seeing relationships between these two courts. We are seeing relationships between the two cases. That court, the European Court of Human Rights, has its own website and cases. And at the bottom, we have origin and host. And I'm just looking at Teresa to see, how am I doing for time?
11:30.
So I really got to try and wrap up. All right, I tell you what I'm going to do is, I'm going to stop at 12:20. So 7 minutes. So at the bottom, we're looking at origin state rules and host state rules, and it really aids your analysis of these cases if you break the cases down involving the freedoms down into either origin state cases or host state cases. When I do that, I can say that, of course, one member state can be an origin state one day, and the next day, in another case, it can be a host state case. And two classic cases are, from a UK perspective, is to look at Commerce Bank, a German bank with a branch in the UK, and Marks and Spencer's, which was an origin state case. The difference between the two is, in an origin state case, you're doing something to one of your own nationals. In a host state case, you're doing something usually to a foreigner who's exercising the freedom, one of the freedoms in your country. Now, whenever there's a foreigner involved in the comparison, so this is the word comparability. So the comparability in the yellow box, this is another concept. You're always comparing the different treatment of two people. So different treatment of two people is what it's all about, the cases. In an origin state environment, it's going to be the different treatment of two origin state nationals. In a host state environment, it's going to be the different treatment, usually 99% of the time, of a foreigner and a local in the host state. So it's a foreigner who's come to your state as a worker. It's a foreign service provider who's come to the host state as a worker, as a service provider. It's a foreign company that set up a branch in your country. Or it's a foreigner who has invested in your country. Or it's a foreign person who has moved to your country to retire and using EU citizenship rights. So there are 5 cases to read on origin cases and 5 on host. 5 to read on origin, 5 to read on host. If you read De Groot and Schumacher on workers, Marks and Spencer's and Our Fiscal on establishment, Eurowings and Garitza on services, Manninen and Boanish number 1 on capital, and Turpainen and Martinez Sala, I would say that you will get a very, very good understanding of the types of issues that you can come across because we cover all the options. You cover origin state cases, you cover host state cases, and you cover each of the freedoms from an origin or a host basis. And you also cover EU citizenship. So what's going on and why do I analyze these cases differently? Well, in relation to host state situations, because you're treating a foreigner less favorably than a local, you can do that in 3 different ways. You can treat the foreigner less favorably on grounds of nationality. A classic example of that is the Royal Bank of Scotland case. They set up a branch here in Greece. The Greek government don't like foreign banks trading here, so they charge them 40% tax. And if you were a Greek bank with a branch here, you were charged tax at 35%. And this was seen as discrimination on grounds of nationality, and the Greek government obviously had to change the rules as a result of the European case. So the first thing you can do is discriminate on grounds of nationality. The second thing you can do is indirectly discriminate on grounds of nationality. And we see an example of that in a case called Beal, B-I-E-H-L. Indirect discrimination is where your rule may apply to local people and to foreigners in the same way, but your rule is really designed to attack foreigners. And the Beal case was an example of Luxembourg refusing to give back a repayment of overpaid tax if you left during the tax year. And the court said, if you leave during the tax year, you're probably going to be a foreigner going back home. Because it's mainly foreigners who are going to be going back home during the tax year. So if your rule mainly affects foreigners, that rule can be discriminatory on grounds of nationality. And lastly, you can have a restriction. And a restriction is another one of these words that is in the yellow box. The concept of restriction is that you are doing something to impede, to hinder, to deter, to discourage, to make less attractive the exercise of one of the freedoms. And the court has told us in a case called De Groot that my students read for my individuals workshop yesterday, that the member states must respect the principle of national treatment of nationals of other member states and of their own nationals who exercise the freedoms guaranteed by the treaty. So the respect the principle of national treatment means that if a foreigner comes to your country and they're in a comparable situation to you, they should receive the same tax treatment as you. If an origin state environment, if a local is exercising one of the freedoms, they should receive national treatment and not be treated less favorably just because they're exercising one of the freedoms. So the court gives us a clear statement of the law in paragraph 94 of De Groot. You must respect the principle of national treatment of nationals of other member states. That means a host state environment, and of your own nationals who exercise the freedoms. Own nationals is usually going to be an origin state environment, but remember, it could be a host state environment in one situation. So as you can see at the bottom of the slide on the left, it says it can also be a host state national. So for example, if we have a German person living in Germany, not doing anything outside of Germany ever, that German person has not switched on his or her EU law rights. It's only when you exercise one of the freedoms that you switch on the right. So you may have to go out of Germany to work and come back into Germany. And when you come back into Germany, and if you have worked as an EU worker or had a business or provided services in another member state, then you're coming back in as a German with EU law rights. And you have to be treated like a foreigner coming back into your own country. And there's a classic German case on this called Singh, Mr. Singh. I think he went out of Germany, came back in with a foreign wife, and the question was whether or not he could bring that foreign wife into Germany and set up a business in Germany. And the court said yes, because he has gone out and switched on his rights because he worked as a worker in another member state. So these cases sometimes involve host state nationals, but usually you're dealing with a real foreigner compared with a local. In an origin state environment, you're dealing with two origin state nationals. So I would encourage you to look at two things. I would encourage you, first of all, to have a look at Commerce Bank and Marks and Spencer's, because they give you an example of the UK, first of all, acting as a host state, causing a problem in the host state in the Commerce Bank case. And then Marks and Spencer's, a UK rule causing a problem for one of its own companies exercising establishment rights in other member states. And then I would suggest that you look at these 10 cases, do the 5 origin cases together, see the origin issues. It's always going to be involving 2 locals. And then go to the host state cases, and it's always going to involve a foreigner and a local, a foreign company or a foreign individual and a local. So I'll leave it at that, and I'll take any quick questions. But basically, the triangle model, you're going to come across 3 types of cases in the court's case law. You're going to come across competence cases. A competence issue is where we no longer have the power to do something. An example of a competence issue is we no longer have the power at the member state level to tax the salaries of EU officials. That power to tax went to the EU when the EU was formed. So if a member state tries to tax the salary of an EU official, that's a breach of competence. They don't have the power to do that, so the member state has gone beyond its competence. Most of the cases that you're going to see and read involve compliance. Complying with EU law. Every case that we've discussed yesterday and today is almost all compliance. And then I have a third type of case that you come across, and I put DTC, which is a double tax convention. These cases cause problems in an EU environment that are not problematic at all outside the EU, but they are problematic in the EU because of the national treatment principle. So whenever a tax treaty intersects with the national treatment principle, Gottardo tells us the tax treaty must comply with EU law. So if the tax treaty does not grant national treatment in the host state, then Gottardo tells us that that tax treaty will have to be fixed through amendment or through termination. So I leave my triangle model with you. I can give you the basic talk that I've just given in writing because it's published, and I'll get a copy of that to Teresa. We didn't really go into justifications and proportionality, but never mind. I mean, I think you get the basics from what I just said. And these are your two big diagrams, this one and the triangle model. If you can understand these two diagram slides, then I think that you get a very good understanding of what I was talking about. And then you get your deeper knowledge, your added value from reading these 10 cases and understanding the difference between origin situations and host situations. At the time, I used to call these my migrant, non-migrant test. And they're basically a national treatment test. So it's a national treatment test. You're comparing two nationals from an origin environment, or you're comparing two nationals in a host environment, one of whom is a foreigner. So I think I was right when I came up with the idea of a migrant, non-migrant way back in 2003 or 2004. The court's case law has not changed. The only recent case development in this area is that there is a set of facts in SOPORA, S-O-P-O-R-A, where the court doesn't apply national treatment, it applies equal treatment to two foreigners working in the same country. So the court applies the equal treatment principle in SOPORA. I wrote a very good article on it, it's published. Again, I'll get that to Teresa. Look, I've got to wrap up because we have the bus coming at 1 o'clock. Sorry that I went a little bit over the time on this, but Thomas is coming next and he's a super speaker and I want to give him some floor time. So thank you very much, everybody. Thank you.